Good day to you and welcome to another Paddocks Club video tutorial. Today I'm going to deal with the last of three in a series that I've done on the Sectional Title Schemes Management Act, which, as you know, is not yet in operation, but which will come into operation, we expect, in the course of the first half of next year. In the earlier tutorials, I dealt with an introduction. I gave you an overview of the Sectional Title Schemes Management Act and the regulations. Today I'm going to unpack the annexures. And these comprise 5 different components. Firstly, the management rules, then the conduct rules, then a couple of forms, then the internal dispute resolution provisions, and finally a managing agent code of conduct. Let's start with the management rules. Part 1, this looks pretty familiar, I guess, is an introductory part. It deals with the interpretation of those rules, the amendment of them and their binding nature, and also service addresses, very close to the existing layout. The service address provision does cater for e-communications. In Part 2, we deal with the trustees, how many there will be, the requirements for office and disqualification, nomination, election replacement, payment and indemnity. That's all more or less, I think, the same as things are at the moment, except that there's a distinction made between very small schemes. Those are that have less than 4 primary units in them. And for those, there are different provisions, or certain of the other rules don't apply if you're a very small scheme. Then we move on to Part 3 that deals with trustee meetings and decisions. Again, this is on the basis of what's there originally, except that in the calling and attendance of meetings, there is provision for telephone and e-meetings. And in the quorum, there is provision for interim resolutions, where if you can't get a quorum, the people who are there can take an interim resolution, and you wait then for confirmation of that. It's a process where you basically turn the current position on its head. You don't say if you can't get a quorum, you can't do any business. You say if you can't get a quorum, you do the business, and unless sufficient number come and say we don't like it, it then sticks after a short period. Moving on to owner meetings in Part 4. This deals, as you can see, with all the normal stuff. Notice the first general meeting, the annual and special general meetings. It gives more details as to exactly what must happen in those meetings. And the role of the chairperson is spelt out in more detail than is currently the position. In the voting and representatives, if a special resolution is taken with less than 50% quorum of 50, then of all people, if the quorum is less than 50% of all the votes in the scheme, then again you have this interim situation where within 1 week thereafter, 25% of the votes can ask for a meeting to reconsider, and if they do, then the resolution can't be implemented until that subsequent meeting has dealt with it. But if they didn't turn up for the first meeting, chances are they won't get their act together in a week to call for a reconsideration. Part 5 deals with financial management, the financial year, functions and powers. It does contain a provision that the interest on overdue levies is limited to that determined under the Prescribed Rate of Interest Act, which is currently 15.5%. There is provision for a maintenance, repair and replacement plan. Remember, these days you have to, under this Act anyway, you will have to have a reserve fund. And this is the way you plan as to how much money has to go into the reserve fund. Insurance, then administrative and reserve funds, the separation of these two lumps of money and how you transfer money between them. Contributions and charges, financial records, budgets, reports and audit. The audit requirements are also spent out in a bit more detail. Part 6 deals with administrative management, governance documents and records, a bit more detail, and managing agents. There's provision for an executive managing agent. If a scheme cannot get trustees or doesn't want to have trustees, it's able to appoint one person to fulfill the functions of the trustees. And under the Community Scheme Ombuds Service Act, an adjudicator can appoint an executive managing agent for a scheme. It's a sort of a halfway step between management by a group of volunteer trustees on the one hand and administration on the other. Part 7 is physical management. This deals with improvements to common property and deals specifically with the installation of prepaid meters. the use of sections and component properties, and the obligation to maintain. When we move on to the conduct rules, it's more or less the same territory that you are dealing with in the current ones. In fact, we've consolidated a few of them, so it should be shorter. Rather than 11 of them, there'll only be 8 of them. And then finally, there is a set of forms. The proxy form is there, and the notice of dispute form is there. There's an internal dispute resolution procedure which is applicable to all schemes if they don't have their own. And finally, a code of conduct for managing agents. I hope that this has been useful to you. If you have any questions, please let's deal with them in the discussion forum.